Pregnancy and parental leave are some of the most common types of leave for California employees. So this video is going to discuss three things. First, it's going to discuss the statutes that provide you protections for pregnancy and parental leave. Then we're going to discuss the obligation your employer is required to undertake if you request those types of leave. And also we're going to talk about prohibited conduct that your employer cannot engage in for you requesting those types of leave. So let's just jump into it. So under California law, we have two main statutes that govern pregnancy disability leave and also parental leave. Number one, the Pdll, the Pregnancy Disability Leave Law. And the second thing is CFRA, the California Family Rights Act. So our office prepared this 25-page outline that's discussing your rights under pregnancy leave and parental leave. So we're going to be discussing a lot of what's on this document. Now, if you're interested in purchasing this document, you can find the link in my bio and you can purchase it on our website. The first thing we're going to discuss is Pregnancy Disability Leave Law, Pdll. So the Pdll is a primary California statute providing pregnant employees the right to pregnancy disability leave, PDL. The Pdll prohibits discrimination, harassment, retaliation, and other employer actions against employees and applicants based on pregnancy, perceived pregnancy, childbirth, breastfeeding, and any related medical conditions. The Pdll offers up to 4 months of unpaid job-protected leave for an employee who has a disability that's related to a pregnancy. And all California employers with 5 or more employees are covered by the Pdll. So if you work for a company that has 5 or more employees in 1 calendar year, you're covered under the Pregnancy Disability Leave Law. Now let's talk about the employees that this applies to. Any woman or transgender employee who works for a covered employer is subject to these types of laws. Now what that means is it doesn't matter how long you've worked at the employer for, and it doesn't matter if you're full-time or part-time. You still qualify for Pregnancy Disability Leave Law if you work for a covered employer, meaning that that employer has 5 or more employees. Now let's talk about who qualifies for Pdll. Now we just go into the outline. Employees are eligible for leave under the Pdll if, in the opinion of their health care provider, they 1. Cannot, because of a pregnancy, perform any one or more of the essential functions of their job, or any of the essential functions of their job without undue risk to self, to their pregnancy's successful completion, or to other persons. Also, it applies to anyone who suffers from severe morning sickness, or if they must take time off as a result of their pregnancy, childbirth, or related conditions, including but not limited to prenatal care, postnatal care, bed rest, gestational diabetes, pregnancy-induced hypertension, preeclampsia, postpartum depression, loss or end of pregnancy, or recovery from childbirth, loss, or end of pregnancy. Now let's talk about leave and accommodation under the Pdll. Covered employees are eligible for disability leave, temporary job transfer, or a reasonable accommodation under the Pdll. Now let's look at leave time. The Pdll provides up to 4 months of unpaid job-protected leave to employees who are disabled by pregnancy, childbirth, or a related medical condition for each pregnancy, and the 4-month leave period is determined by the number of hours an employee would normally work within 4 calendar months or 17 1/3 weeks. For a full-time employee who works 40 hours per week, this would entitle the employee to 693 hours of leave, which is 40 hours per week multiplied by 17 1/3 weeks. Otherwise, the number of working days that constitute 4 months is calculated on a pro rata or proportional basis for employees who either work less than 40 hours per week, more than 40 hours per week, or variable work schedules. For example, for an employee who works 20 hours per week, 4 months means 346.5 hours of leave. If they work 48 hours a week, 4 months means 832 hours of leave. If an employee's schedule varies from month to month, a monthly average of the number of hours worked over the 4 months before the beginning of the leave must be used to calculate the employee's normal work month. When a holiday falls within a leave week, that week will be counted as a full week of PDL. Temporary business closings of 1 or more weeks, for example, school closings or for Christmas or a holiday break, however, do not count against PDL entitlement. Now let's talk about intermittent leave or reduced work schedule. Leave may be taken intermittently or on a reduced work schedule basis. Employers calculating intermittent Pdll can count leave time using increments no greater than 1 hour. If employers offer other kinds of leave in smaller increments, they must use that smaller increment to count intermittent Pdl. For example, if an employer tracks sick leave in 30-minute increments and vacation time in 1-hour increments, the employer must track Pdl in increments of 30 minutes or less. Or other forms of leave in 2-hour increments, the employer must track Pdl in increments of no greater than 1 hour. Now, one question is, how does the Pdl interact with other types of protected leaves? Well, the Pdl runs concurrently with leave taken under the FMLA, the Family Medical Leave Act. An employer may count up to 12 weeks of an employee's Pdl against the employee's federal FMLA entitlement. Pdl, however, is a separate and distinct right from leave under the state's CFRA, and the two types of leave run consecutively for a maximum leave entitlement of up to 29 1/3 weeks. If an employee is eligible for both types of leave, an employee may take up to 17 1/3 weeks of Pdl and 12 weeks of CFRA leave. Now, both employers and employees should be aware that Pdl is limited to the period in which the employee is actually disabled from pregnancy, childbirth, or related conditions. CFRA leave is subject to eligibility requirements and may be less than 12 weeks if leave has previously been taken or other qualifying reasons within the designated CFRA leave year. Extended leave and other temporary disabilities. If an employer's leave policy for similarly situated employees with other types of temporary disabilities allows for more than 4 months of leave, the employer's more generous leave policy must be extended to employees otherwise entitled to Pdl. For example, an employer may provide greater than 4 months of leave due to its own temporary leave policies, a collective bargaining agreement, a reasonable accommodation, However, an employer may differentiate those types of leaves for non-occupational disabilities and occupational disabilities. In such cases, an employer could lawfully limit leave for disabilities for pregnancy, childbirth, and related medical conditions to the period allowed for non-occupational disabilities while providing greater leave entitlements for occupational disabilities. An employee that continues to have a pregnancy-related disability at the conclusion of her Pdl may request that her employer allow her to take CFRA leave before the end of her birth. Employees are not required but may permit a pregnant employee to use CFRA leave when it is medically necessary and Pdl has been used in its entirety. An employer may also be required to provide additional leave for a pregnancy-related disability under the Fair Employment and Housing Act. In the case Sanchez v. Swissport, Inc., the California Court of Appeal concluded that the FEHA may require an employer to provide a pregnant employee with a reasonable accommodation in connection with a pregnancy-related disability. The court noted that the right to take leave under the Pdll is a separate and distinct right from the right to take leave under the FEHA. So an employee with a pregnancy-related disability at the end of her Pdl may be entitled to a reasonable accommodation, including additional leave. This is something really important to know. Now, what do reasonable accommodations look like for pregnancy or parental leave? In addition to leave, employees are also entitled to reasonable accommodations, such as a job transfer, modifications or restrictions to job duties, reduced work schedule, permission to work from home, the right to use a chair or water bottle, more frequent or longer breaks. An employer must provide a reasonable accommodation to a pregnant employee if the employee's healthcare provider recommends that the employee receive the accommodation and the accommodation is reasonable. Now, employers may require the employee to provide a medical certification establishing the employee's need for a reasonable accommodation. Whether an accommodation is reasonable or not is actually a fact-intensive and fact-specific analysis. An individualized inquiry based on the totality of the circumstances and then the employer must consider the employee's medical needs, the duration of the needed accommodation, the employer's legally permissible past and current practices, and any other factors applicable to the accommodation request. An employer may not force an employee to take a leave of absence because of pregnancy or perceived pregnancy when the employee has not requested leave. So reasonable accommodations other than intermittent leave or a reduced work schedule will not affect an employee's independent right to take up to 4 months of Pdl. When intermittent leave or reduced work schedule is provided as an accommodation, an employer may consider it a form of pregnancy leave and deduct hours from the employee's 4-month leave entitlement. If an employer denies an accommodation request, it then has the burden of proving by the preponderance of the evidence that an accommodation is not reasonable. So this is something good to know. Now let's talk about the interactive process. Once an accommodation has been requested or the need for an accommodation is identified, an employer should engage in the interactive process. While the Pdll regulations do not specifically describe the interactive process, employers must seek guidance from the FEHA's disability discrimination regulations for guidance. When engaging in the interactive process, employers should 1. Analyze the job at issue and determine its purpose and essential functions. 2. Consult with an individual with a disability to ascertain the precise job-related limitations imposed by the individual's disability and how those limitations could be overcome with a reasonable accommodation. Also, the interactive process includes working with the individual to be accommodated. So you need to identify that individual's potential accommodations and also assess the effectiveness each would have in enabling the individual to perform the essential functions of that position. The employer must also consider the individual's preference and select and implement the accommodation that is most appropriate for the employer and the employee. The accommodation offered need not be identical to the accommodation requested because you're interactively engaging with both parties. Let's talk about job transfer rights. Job transfer rights and limitation. The Pdll specifically provides that a job transfer during pregnancy disability is a reasonable accommodation. Employers must provide employees affected by pregnancy the same rights as they do other temporarily disabled employees. This includes transferring the pregnant employee to less strenuous or hazardous positions or duties for the duration of the disability, if requested by the employee. Employers may not deny a request for job transfer if both of these happen. Number 1, the employee's request is based on their healthcare provider's advice that the transfer is medically advisable. And 2, the employer can reasonably accommodate the transfer if the employer is not required to 1. Create additional employment the employer would not have otherwise created. 2. Discharge another employee. 3. Violate the terms of a collective bargaining agreement. 4. Transfer another employee with more seniority, or promote or transfer an unqualified employee to a new position. Now, employers may transfer another employee to accommodate a pregnant employee's request for a job transfer, but are not required to do so. An employer also may require a pregnant employee to provide a medical certification establishing the needs for that job transfer, and the employer may also require a pregnant employee taking intermittent leave or working on a reduced work schedule to transfer temporarily to another position if the employee is qualified for the other position has equivalent pay and benefits, although it's not necessarily 100% certain they need to have the same duties, and the other position better accommodates the employee's leave requirements than the employee's previous job. And once the need for the accommodation ceases, employers must reinstate the employee to their same or comparable position. Lactation break requirements and accommodations. The Pregnancy Disability Leave Law provides that lactation breaks are a reasonable accommodation under the Labor Code. California employers are generally required to provide lactation breaks to female employees who express breast milk for their infant child. Employers may be exempt if they can show that providing breaks would seriously disrupt their operations, and California employers with more than 50 or more employees covered by federal law are not entitled to exemptions. Now, unless they can show an undue hardship, employers must make reasonable efforts to provide a private room or location, other than a bathroom, in close proximity to the employee's work area for an employee or to express milk unless they can show undue hardship. Employers that can show an undue hardship, considering the size, nature, and structure of the employer's business, must make reasonable efforts to provide the use of a room or other location other than a toilet stall in close proximity to the employee's work area for the employee to express milk in private. Although no specified frequency or amount of time is required, an employer must allow reasonable breaks, which, if possible, should run concurrently with the break time already provided under California law. If the lactation break overlaps with a non-exempt employee's break time under California wage and hour laws, employers must pay employees for the break period. Lactation breaks that extend beyond an employee's normal break periods may be unpaid. Now, if you're a California employer and you want a lactation policy, then you should contact our offices and we could help you come up with one. Employers are not required to pay an employee during PDL. However, if an employer pays for other temporary disability leaves for similarly situated employees, the employer must also pay employees during PDL. Employers may require an employee to use any accrued sick leave during that unpaid portion of PDL, or the employee may choose to do so. Unlike with sick leave, an employee taking PDL may choose, but an employer cannot require, use of the following types of accrued time during unpaid PDL: vacation time, paid time off, and undifferentiated PTO. Employees may also be eligible for California State Disability Insurance, SDI, for partial wage replacement during leave. The SDI program provides partial wage replacement benefits to workers who are unable to work due to a non-work related illness, injury, or pregnancy for up to 52 weeks. For information, go check the EDD's website. New section, Notice and Certification Requirements. Employee notice requirements. An employee requesting PDL, transfer, or reasonable accommodation must provide at least 30 days advance notice before the start of the leave, transfer, or reasonable accommodation. This notice may be verbal or written, but I advise that it's written. Must be sufficient to make the employer aware that the employee needs PDL, transfer, or reasonable accommodation, and must include the anticipated start date and duration. If the PDL, transfer, or reasonable accommodation is foreseeable and the employee fails to give timely advance notice, the employer may delay the leave, transfer, or reasonable accommodation until 30 days after the employee provides notice, unless the delay would endanger the employee's health or pregnancy, the health of the employee's coworkers. If there is an unforeseeable change in circumstances or a medical emergency prevents the employee from providing 30 days advance notice, notice must also be given as soon as practicable. Under such circumstances, an employer may not deny leave, transfer, or reasonable accommodation on grounds that the employee did not provide adequate advance notice. On receiving notice of a request for PDL, transfer, or reasonable accommodation, an employer must respond to an employee's request as soon as possible and in any event no later than 10 calendar days after receiving the request. And they also must attempt to respond to a leave request before the date leave is set to begin. Once approval is given, it's deemed retroactive to the first day of leave. Now we're talking about medical certifications. What kind of documents can your employer require you provide them to show that you are entitled to this type of leave? Employers can require employees to provide written medical certification by a healthcare provider as a condition of granting an employee's request for PDL, transfer, or reasonable accommodation. If so, the employer must notify employees of the need to provide medical certification, the deadline for providing certification, what constitutes sufficient medical certification, and consequences for failing to provide medical certification. An employer seeking a medical certification must notify employees of the medical certification requirement each time a certification is required, and also advise employees of the consequences for failing to provide adequate medical certifications or doctor's notes, and inform the employee if a medical certification form is inadequate or incomplete, and allow the employee to allow the employee a reasonable opportunity to cure the deficiency. They also must provide employees with an employer-required medical certification form for the employee's healthcare provider to complete. For a sample PDL medical form, you can contact our offices. A request for medical certification must be made either at the time the employee makes a request for PDL, transfer, or reasonable accommodation, or within 2 business days after the request is made. If the request is for an unforeseeable leave, an employer must make a request for medical certification within 2 business days after the leave commences. An employer must also notify employees of the time frame for submitting a completed medical certification form, which must be at least 15 calendar days, unless it's not possible despite the employee's good faith efforts, after the employer's request for the certification. The certification of the medical advisability of PDL is sufficient if it contains, so it needs to contain these things: a statement that the employee needs to take PDL because of being disabled by pregnancy, childbirth, or a medical-related condition, the date on which the employee became disabled because of the pregnancy, the estimated duration of the leave, a certification of the medical advisability of a reasonable accommodation or transfer is sufficient if it contains a description of the requested reasonable accommodation or transfer, a statement describing the medical advisability of the reasonable accommodation or transfer because of pregnancy, the date on which the reasonable accommodation or transfer became or will become medically advisable, and the estimated duration of the reasonable accommodation or transfer. If all of these above requirements are met, the employer must accept it as sufficient The employer may not ask the employee to provide additional information, and the employer may not require recertification if both the estimated time for leave, the reasonable accommodation, or transfer expires, and the employer requests additional time. Any medical information contained in the certification must be kept confidential by the employer. If an employee's sick or medical leave plan has less stringent medical certification requirements and the employee uses sick leave, vacation time, or personal or family leave during unpaid Pdll, only the employer's less stringent leave certification requirements may be applied. If the need for Pdll, reasonable accommodation, or transfer is foreseeable and an employee fails to provide the requested certification in a timely manner, the employer may delay granting the leave or reasonable accommodation, or transfer until the certification is provided. Where the need for Pdll, reasonable accommodation, or transfer is not foreseeable, or in the case of recertification, an employee must provide the requested certification either within the time frame requested by the employer, which must be at least 15 calendar days after the employer's request, unless it's not possible despite the employee's good faith efforts, or as soon as possible under the circumstances. The Pdll, the Pregnancy Disability Leave Law, defines broadly the types of healthcare providers who can provide medical certification of a female employee's need for Pdll, reasonable accommodation, or transfer. A healthcare provider is defined as any of the following: a medical or an osteopathic doctor, physician, or surgeon who is licensed in California or in any state or country and directly treats or supervises the treatment of an applicant or employee disabled by pregnancy, childbirth, or related medical condition, or a condition related to pregnancy, childbirth, or a related medical condition. It can also be a marriage and family therapist or acupuncturist who is licensed in California or in another state or country and directly treats or supervises the treatment of a female applicant or employee disabled by pregnancy, childbirth, or related medical condition, or a condition related to pregnancy, childbirth, or a related medical condition. It also could be any other person who meets the FMLA's definition of others capable of providing healthcare services and who directly treat and supervise the treatment of a female applicant or employee disabled by pregnancy, childbirth, or a related medical condition, or a condition related to pregnancy, childbirth, or that related medical condition, including nurse practitioners, nurse midwives, licensed midwives, clinical psychologists, clinical social workers, chiropractors, and physician's assistants. A healthcare provider for whom an employer or group health plan's benefits manager will accept medical certification of the existence of a health condition to substantiate a claim of the benefits. Or it could be a healthcare provider for whom an employer or group health plan's benefits manager will accept medical certification of the existence of a health condition to substantiate a claim for benefits. Let's talk about the return to work release. Return to work release. Employers can require a return to work release before allowing employees on Pdll or transfer to resume working at their original job or duties. However, the policy of requiring these releases must be uniformly applied to the other similarly situated employees returning to work after a non-pregnancy related disability leave or transfer. The employer notice requirements are here too. Employers must provide reasonable advance notice to employees of their pregnancy-related rights under the Pdll by properly distributing information about all of the following: the employee's rights to request that leave, the reasonable accommodation, a transfer, or Pdll, the employee's obligations to provide the employer with adequate advance notice of the above needs, and the employer's requirements, if any, that employees provide medical certification or the need for reasonable accommodation, transfer, or leave. Notice of an employee's rights to leave, transfer, reasonable accommodation under the Pdll must be posted in the workplace in conspicuous places where employees gather, or be posted electronically. It also must be provided as soon as possible after an employee either tells the employer of the employee's pregnancy or inquires about reasonable accommodation, transfer, or Pdll. Regarding the Pdll notice, employers must also translate the notice into every language that is spoken by at least 10% of the workforce. If 10% or more of an employee's workforce at any facility or establishment is comprised of persons whose spoken language is not English, and make a reasonable effort to give verbal or written notice in the appropriate language to any employee who the employer knows is not proficient in English and was not given written notice of their Pdll rights in their primary language. Employers that maintain an employee handbook describing temporary disability leave rights must include a description of Pdll rights in the handbook, If the employer does not have an employee handbook, it must distribute a copy of the notice to Pdll rights to employees at least annually, which also may be electronically. For a sample Pdll policy, please contact our offices and we can get your business all situated up. Employees that take Pdll are entitled to be reinstated in the same position or, under limited circumstances, a comparable position. They're able to retain their employment status with no break in service for seniority or benefit plan purposes. And also, they are entitled to continued health care coverage. When we're talking about the reinstatement to the same position, employees returning from Pdll or a transfer are guaranteed to return to the same position that they held before the leave or transfer. An employer must provide the guarantee in writing if requested by an employee. A permissible defense to this obligation is if an employer can prove by the preponderance of the evidence that an employee would not otherwise have been employed in their same position at the time of the requested reinstatement because of legitimate business reasons unrelated to the employee taking Pdll or transfer, such as a layoff resulting from a plant closure. If an employee cannot be returned to the same position or duties because the employer has a permissible defense, the employee is entitled to be returned to a comparable position unless the employer can show by a preponderance of the evidence the employer would not have offered a comparable position to the employee if they would have worked continuously during the Pdll or transfer period, or there's no comparable position available. A position is available if there's a job open on the employee's scheduled date of reinstatement or within 60 calendar days after the conclusion of the leave, for which either the employee is qualified and the employee is entitled by company policy, contract, or CBA, collective bargaining agreement. Employers have an affirmative duty to inform the employee of available positions during the requirement period, which is not specifically defined but is presumed to refer to the scheduled date of reinstatement plus 60 days. And employers must use methods that are reasonably calculated to inform the employee of comparable positions, such as providing notice in person, by letter, by telephone, by email, using links posted to the employer's website. Employees do not have greater rights to reinstatement to the same or comparable position or to other benefits and conditions of employment than those rights they would have had if they had not taken Pdll or a transfer and had been continuously working. This is the case even if the employee has a written guarantee of restatement on returning from Pdll or transfer. If an employee is laid off during Pdll or transfer for legitimate business reasons unrelated to the leave or transfer, the employer is no longer required to provide and continue the employee's Pdll or transfer, maintain the employee's benefits, or reinstate the employee. If the employees take additional leave under the CFRA after their Pdll expires, the CFRA's reinstatement provisions apply, which provide for reinstatement to the same or comparable position. If another type of leave is taken after Pdll expires, the employee's reinstatement rights are the same as any other similarly situated employee who has taken a similar length of disability leave under the employer's policy, practice, or collective bargaining agreement. Employers should take note that if the Pdll was also designated as FMLA leave of 12 weeks or less, the reinstatement provisions of the FMLA apply and the employee must be reinstated to the same or equivalent position absent a key employee defense. Now let's talk about employee status, seniority, and benefits when you take Pdll. Employees on Pdll must retain their employee status during the leave, and the leave must not constitute a break in service or purpose for any of the following: longevity, seniority under a collective bargaining agreement, employee benefit plans, and employees taking Pdll must be treated the same as employees taking other types of unpaid disability leave regarding the terms of the employment, including accrual of seniority, participation in employee benefit plans, including life insurance, short-term disability, long-term disability, accident insurance, stock options, pension and retirement plans, and supplemental unemployment. While on Pdll, an employee continues to accrue seniority if their employer's policy allows seniority to accrue when the employees are on paid sick leave, paid vacation time, and unpaid leave. When the employee returns from Pdll, benefits must be resumed in the same manner and at the same levels before Pdll without any new qualification period, physical exam, or qualifying provisions. Also, the employee must return with no less seniority than when the leave began. Now let's talk about continued health insurance coverage. Employers must maintain and pay for health insurance coverage under a group health plan during the time an eligible employee takes Pdll. This continued coverage may not be used to meet an employer's obligation, in the case of employers with 50 or more employees, to pay for 12 weeks of group health coverage during the leave taken under CFRA, even if an employee's Pdll has been simultaneously designated as FMLA leave. Entitlements to employer-paid group health coverage during the leave taken under the Pdll and CFRA are two separate and distinct rights. The continuation of group health coverage must begin on the date that Pdll begins and continue for the duration of Pdll up to a maximum of 4 months or a 12-month period. The continuation of group health coverage must begin on a date that Pdll begins and continue for the duration of the Pdll up to a maximum of 4 months in a 12-month period. Be provided at the same level and under the same conditions as if the employee had not taken leave. Employers may maintain and pay for group health coverage for longer than 4 months, and if an employee fails to return after the Pdll has expired, the employer may recover insurance premiums from the employee if both of the following conditions are met. If an employee fails to return after their Pdll has expired, the employer may recover insurance premiums from the employee if both of the following conditions are met. The employee fails to return from Pdll after the leave has expired, and the employee's failure to return from leave is not due to the need to take CFRA leave, unless the employee chooses not to return to work following CFRA leave. The continuation, recurrence, or onset of a health condition that entitles the employee to leave under the Pdll, unless the employee chooses not to return to work following that leave. A non-pregnancy related medical condition requiring further leave, unless the employee chooses not to return to work after that leave. Or other circumstances beyond the employee's control, such as the employer's failure to return the employee to the same or comparable position, or the employee's need to care for herself or a family member. Now let's talk about prohibited employer conduct once you take pregnancy disability leave. Employers are prohibited from taking the following actions because of an employee or applicant's pregnancy or perceived pregnancy unless there's a permissible defense. Employers prohibited from refusing to hire or employ an applicant because of perceived pregnancy or pregnancy. The employer is prohibited from refusing to select an applicant or employee for a training program leading to employment or promotion. The employer cannot refuse to provide you employment benefits if those employment benefits are offered to other people on non-disability leaves. Your employer cannot refuse to maintain and pay for coverage under your group health plan for an eligible employee who takes Pdll under the same terms and conditions as if the employee had not taken leave. Your employer cannot refuse to provide you a reasonable accommodation for an applicant or employee affected by pregnancy. An employer cannot refuse to transfer an employee affected by pregnancy, or an employer cannot refuse to grant Pdll to an employee disabled by pregnancy. An employer also cannot bar or discharge an applicant or employee from employment or a training program leading to employment or promotion. Your employer can't discriminate against an applicant or employee in terms, conditions, or privilege. An employer also cannot discriminate against an applicant or employee in terms, conditions, or privileges of their employment. Your employer can't harass an applicant or employee, which applies to employers with one or more employees. Write that down. And your employer cannot transfer an employee affected by pregnancy to another position over their objections unless the employer can prove that the temporary transfer to another job is needed to accommodate the employee's intermittent leave or reduced work schedule, and the temporary job meets certain requirements. Your employer also cannot require you to take leave in absence because of pregnancy or perceived pregnancy when you have not requested leave. The employer also cannot retaliate, discharge, or otherwise discriminate against an applicant or employee because the person has opposed employment practices prohibited by the FEHA. You complain about violations of the law, or if that employee has filed a complaint, testified, or assisted in any proceeding under the FEHA. Your employer also cannot otherwise discriminate against an applicant or employee by any practice that is prohibited based on sex, and your employer cannot deny or interfere or restrain your rights to reasonable accommodation, job transfer, or taking Pdll. Now, we talked a little bit about the defenses that your employer has by engaging in this type of conduct, and some of the permissible defenses to any of the above employer actions are bona fide occupational qualifications, business necessity, and actions taken under federal, state, or local law. The CFRA provides covered employees the right to unpaid job-protected leave for employment for certain family or medical leave reasons. In relation to pregnancy leave, it authorizes up to 12 weeks of leave in a designated 12-month period for bonding with a newborn or the serious health condition of an employee's child, including the child of a registered domestic partner. It also provides employees the right to continued disability related to pregnancy, childbirth, or related medical conditions at the employer's discretion after an employee has used all 4 months of their Pdll leave before childbirth. The CFRA requires covered employees to provide eligible employees with unpaid job-protected leave of up to 12 work weeks in any 12-month period. Leave for the birth of a child must be concluded within 1 year from the child's birth. For an employee who wishes to take CFRA leave for childbirth immediately after pregnancy disability leave under the Pdll, the 12-month period in which they must have worked 1,250 hours is the period immediately preceding the employee's first day of pregnancy disability leave, not the first day of the subsequent CFRA leave. Employers may choose to define the 12-month leave period using any of the following methods allowed under the FMLA regulations, such as defining it as either the calendar year, any fixed 12-month leave year, the 12-month period measured forward from the date of the employee's first CFRA leave begins. Employers may choose to define the 12-month leave period using any of the following methods allowed under the FMLA regulations, such as defining it as either the calendar year, any fixed 12-month leave year, the 12-month period measured forward from the date any employee's first CFRA leave begins, a rolling 12-month period measured backwards from the date an employee uses any CFRA leave. And for more information about how to calculate that type of leave, feel free to contact our offices. Now we're talking about intermittent leave. Intermittent leave under the CFRA to bond with a newborn child must be generally taken in a minimum of 2-week blocks. However, an employer must grant a request for a CFRA leave of less than 2 weeks duration on any 2 occasions, and at its discretion may grant additional entitlement leaves of less than 2 weeks. Any bonding leave must be concluded within 1 year after the birth of the child. If CFRA leave is taken for a serious health condition of the employee or child, leave may be taken intermittently as determined by the healthcare provider of the person with a serious health condition. Employers may limit leave to the shortest periods of their time-rolled payroll systems will allow, as long as it's not more than 1 hour. An employer may require an employee on an intermittent leave or reduced schedule to temporarily transfer to an available alternate position for the duration of the intermittent leave or reduced schedule if the alternate position can better accommodate recurring periods of leave than the employee's original position, the employee is qualified for that position, and the alternate position has an equivalent rate of pay and benefits. A temporary alternate position does not need to have equivalent duties of the employee's regular position, but it must not serve to discourage the employee from taking leave or otherwise cause hardship to the employee. Now let's talk about extended leave. Bonding leave or leave for a serious health condition of a child is limited to a maximum of 12 weeks. If an employee has a pregnancy-related serious health condition that also is a disability and cannot return to work at the conclusion of their CFRA leave, the employer has the obligation to engage that employee in an interactive process to determine whether the extension of that leave would be a reasonable accommodation under the FEHA. Now let's talk about the notice and certification requirements for extended leave. The employee notice requirements, unless waived by the employer, an employee must provide reasonable advance notice under the CFRA if the leave is foreseeable. Under the regulations, notice may be verbal. It must state the reason for the leave and be sufficient to make the employer aware that the employee needs CFRA leave, and must include the anticipated timing and duration of the leave. Employers may require that an employee provide at least 30 days in advance notice of the need for leave if the leave is foreseeable. If the need for leave is not foreseeable, notice must be given as soon as practicable. Employers may not deny CFRA leave for an emergency or other unforeseeable event on the basis that advance notice was not provided, as long as the employee provided notice to the employer as soon as practicable. Employers must notify employees of the need to provide advance notice, and if you want more information for this, if you're an employer, please feel free to contact our offices. Medical certifications required. These are the doctor's notes. CFRA leave taken by an employee for bonding does not require that either the employee or the child have a serious health condition, or that the employee no longer is disabled by the pregnancy, childbirth, or related medical condition. The CFRA permits an employer to request a medical certification from an employee's healthcare provider if the leave is being requested for the employee's own serious health condition or the serious health condition of the child. If an employer allows a pregnant employee to use CFRA leave time for a pregnancy-related disability when all of their Pdll leave has been used before the birth of the child, the employer may request additional medical certification from the employee's healthcare provider. The medical certification must include the date the serious medical condition started, the probable duration of the condition, a statement that the employee cannot work or perform one or more of the essential functions of the job due to the serious health condition, and also the medical certification for the child's serious health condition must include the date the serious medical condition commenced, the probable duration of the condition, the statement from the healthcare provider opining that the serious health condition warrants the participation of the employee to provide care during a period of treatment to supervise a child. Activities warranting participation include providing psychological comfort, arranging third-party care, and directly providing or participating in medical care. Now, after all that, if the employee seeks intermittent leave or reduced work schedule, the employer may ask the healthcare provider to certify the intermittent leave or reduced work schedule is necessary, provide the frequency and duration of intermittent leaves, and also certify the medical necessity for an employer to take time off of work for doctor visits or medical treatments. Employers may use the medical certification form provided in the CFR regulations, or alternatively, they may create their own. And if you are here watching this video and you're an employer, you can contact our offices and we can help you create one. Now, there are protections under the CFRA, and these are it. Employees that take CFRA leave are generally entitled to continued health care coverage benefits, retain their employment status with no break in service for seniority or benefit plan purposes, and to be reinstated to the same or comparable position. The CFRA requires that employers maintain and pay for group health plan coverage during the period an employee is on a protected leave. Entitlement to employer-paid group health care coverage during CFRA leave is distinct from entitlement to employer-paid group health care coverage under the Pdll. Therefore, the period of employer-paid group coverage during Pdll may not be used to meet the employer's obligation to maintain coverage under the CFRA. An employee taking leave under the Pdll and CFRA for the birth and bonding with a child is entitled to 29 1/3 weeks of employer-paid group health care coverage. I hope everyone enjoyed this video, and as you noticed, a lot of what I talked about was in this outline that our office prepared. We were talking a lot about parental leave and also pregnancy disability leave under the Pdll, Pregnancy Disability Leave Law, and CFRA, the California Family Rights Act. I hope you enjoy this video, and if you have any questions, feel free to leave them in the comments or send our offices an email. Thank you. Boom!